Mishcon Academy digital sessions.
My name is Neil Bayliss. I'm a partner in Mishcon, and it's my pleasure to be talking to you today about competition law and life sciences. It's an exciting area of law at the moment. So without further ado, let's have a look at the purpose of competition law. So there are a couple of quotes here from the UK and EU competition authorities. So the CMA, which is the Competition and Markets Authority in the UK, says that we work to promote competition for the benefit of consumers. And the EU said that they work to make EU markets work better by ensuring that all companies compete equally and fairly on their merits. It's true to say that pretty much all developed nations now have competition authorities, and they all effectively have the same mandate of trying to promote competition and protect consumers' interests. And they do this really by imposing laws in three areas, as I mentioned before: anti-competitive agreements, abusive dominance, and merger control. So let's have a look at anti-competitive agreements and the four elements for there to be breach of your competition law. First of all, there has to be an agreement, but it's wider than that. It can be any decision made by a group of undertakings or concerted practice, so it doesn't need to be anything formal. It's got to have an effect on trade between the EU member states or under UK law within the UK. Then critically, it has to have as its object or effect the restriction, prevention, or distortion of competition. Worth bearing in mind that whilst that's the provision of EU law, which is mirrored across all the EU member states, there are specific provisions under national laws, and in the UK we have criminal offence under the Enterprise Act. These consequences are serious. This is why competition law is an important area of law. So the fines of up to 10% of group global turnover. Investigations resulting in those decisions often take years. They absorb considerable management time and legal expense. Once a finding of an infringement has been made, then it's very common these days that will be followed by actions and damages being brought by third parties. There's obviously negative PR that goes with that. As mentioned under UK law, we have also the cartel offence, which for individuals carries a maximum 5-year jail term and an unlimited fine. And then in every case of infringement nowadays, the CMA will look to see whether it's appropriate that the directors are disqualified. Just to highlight some of the key elements of an anti-competitive agreement, which are not necessarily obvious. An agreement, certainly as a lawyer, you assume that an agreement means a contract, legally binding contract, but absolutely not the case. Concerted practices can involve any kind of contact between competitors, discussions, undertakings. What do we mean by that? Well, it's any economic entity, effectively. It can be an individual person. Generally speaking, it's going to be a company, and there is a requirement that there must be two or more undertakings, so you can't have a breach of the rules if there's only one person involved. Finally, as you will recall from the previous slide, there has to be object or effect on competition. Now, this is quite a techie area, but effectively, where you have a restriction on agreement, which is so obviously anti-competitive that could have been its only object, then it's deemed to be a by-object infringement, so there's no need to actually prove an economic effect on the market. Where it's not obviously anti-competitive, then it's necessary to discuss the effect on the market and carry out an economic analysis to show there has been an anti-competitive effect. So let's have a look at some of the specific areas where life sciences pharma companies have perhaps found competition law relevant in the past. First is patent pools, which arrangements between multiple owners of IPR to assign patent rights to each other or to grant licenses to third parties. It's generally seen as a positive. They enhance licensing efficiency and access to IP. Second area, which is very important, is that of settlement agreements. So any agreement between a patent owner and an entity that's used or profited from the intellectual property in the patent without the patent's permission. So agreements that restrict a generic company's ability to enter the market or the value transfer from the originator to the generic company will attract the highest degree of commission scrutiny. The restriction of the generic company's ability to enter the market can take various forms. There can be a no challenge clause, a non-compete clause, a license being granted to the generic company. You could have an agreement for the generic company to distribute the originator's product. And likewise, the value transfer can take many forms. It could be direct monetary payment, Could be the grant of a distribution agreement or side deal, could be the conclusion of a license agreement or reimbursement of litigation costs. In particular, I guess it's the pay for delay agreements which tend to be the most controversial, effectively extending the market exclusivity of originators. So, been a couple of cases on this. The Brexit judgment, the CMA found that manufacturers of this drug had colluded to delay the entry of generic versions of the medicine into the market. At the EU level, Teva and Cephalon were fined 60 million euros for agreeing to delay for several years the market entry of a cheaper generic version of Cephalon's drug for sleep disorders after Cephalon's main patents had expired. Various other arrangements which are not uncommon can give rise to competition infringements. Price fixing, obviously, is the classic cartel. Disparagement of market share, an interesting one. So here we had Genentech developed two medicines from related active substances, Avastin and Lucentis. Lucentis was authorised by the European Commission and the European Medicines Agency for treatment of eye diseases, while Avastin was authorised for oncological applications. So a licence for the exploitation of Lucentis was granted to Novartis, while the right to exploit Avastin was licensed to Roche. And before Lucentis was placed on the market, Italian doctors started to prescribe Avastin for the treatment of eye diseases. And this off-label use spread widely in Italy. Once Lucentis was placed on the market, the practice continued because of Avastin's perceived lower price. In 2014, the Italian Competition Authority fined Roche and Novartis 90 million euros each. The Italian Competition Authority concluded the agreement was intended to cause a shift in demand in favour of Lucentis by disseminating information aimed at raising concerns regarding the safety of the off-label use of Avastin for ophthalmological purposes. Two other points there, I haven't got cases for them, but if you have agreements that standardise your terms and conditions of supply, that's an area for competition infringement, and likewise bid rigging and restrictions on exports. This is a sort of the holy grail of EU competition, or if you like, is preserving the single market within the EU. Just mentioned the Falsified Medicines Directive, which is an area of law around marrying the two concepts of A, not wanting export bans, but also B, putting anti-tampering devices on prescription medical products to allow verification that haven't been tampered with. The last area of sort of anti-competitive agreements to look at is information exchange of sensitive commercial information between competitors will infringe competition law. This sort of information sharing is seen as a high object infringement. So you might take the view that competition law is sort of incredibly invasive, and that every agreement which has a restriction in is going to be found to be unlawful and fines. That's not the case. There are two ways in which the law reflects the fact that a lot of these arrangements are actually perfectly acceptable. The first is to allow for an individual exemption to an anti-competitive agreement, and this occurs where you can show that basically the benefits outweigh the anti-competitive effects and that consumers are benefiting from the agreement, as long as the restrictions go no further than those required to achieve those benefits. Competition is not eliminated in its entirety. The Commission recognised early on that it was useful to have what are called block exemptions, so regulations which relates to specific categories of agreement and effectively ensure that there's no need to sort of carry out this assessment each time on an individual basis. For this sector, the most important one is the technology transfer block exemption, which effectively covers patents and know-how, licensing, and also software copyright, design rights, and other IP rights related to production and sale of the contract products. So three other block exemptions just to mention, which are frequently used by companies in the sector. First is the block exemption for R&D agreements. There's a block exemption for specialisation and joint production. Finally, the block exemption for vertical agreements, which is used for the supply distribution of goods. So the other significant area of competition law is abusive dominance. As the name suggests, this is a two-stage test. The first is to look at whether the undertaking is in a dominant position, and you do that by defining the relevant market and then assessing market shares and degree of market power of the company concerned. But if you have that degree of market power and then you abuse your dominant position, then that is serious. When we're looking at abuse, there's no sort of formal list of what is an abusive dominant position, but there are examples given, and broadly, you can define them in two different ways. You can either say that you've exploited consumers with your abuse, and that's first category there, or you've harmed competitors. It's sort of excluded competitors from the market. What do you do if you are the victim of anti-competitive conduct? There's generally two things you can do. First is to complain to regulators. The other option, which doesn't necessarily have to be one or the other, but generally speaking, it is, because the regulator won't pursue a case if it's being litigated, would be to bring a claim for damages, either as a standalone claim or follow-on claim as a result of an infringement decision. If your own company has infringed competition law, then that comes to light. You've got a number of decisions you can make. First is whether to make a leniency application. If you are being investigated, then it's generally sensible to comply with that. And then settlement. So effectively, it's a full form of confession, not the same as leniency. Sort of as the investigation progressed, you're saying, yeah, we now prepare to allow you to draw the matter to a close by agreeing what we did was wrong. And obviously, following all that, you want to identify sort of what was it went wrong, and take appropriate measures to make sure that doesn't happen again. Another hugely important area of law is merger control. So what transactions of courts just got two separate regimes now. Usually what starts with an EU merger control analysis, which support where there's been an acquisition of decisive influence and the companies involved hit relevant revenue thresholds at global and EU level. And this is a mandatory regime, so there's no option but to file and seek clearance prior to closing. Fines will be imposed for gun jumping. In the UK, we have a more expansive test for change of control, so the acquisition of material influence, which can be found with as little as a 15% equity stake. And then in terms of thresholds, it's £70 million UK turnover, buying share of 25% in the relevant market. Now, UK is one of the very few regimes which still has a voluntary regime. Both the UK and EU have a procedure of a phase one investigation, generally 1 or 2 months to look at the transaction, decide whether it gives rise to issues. If it does, then it moves into a phase two, which will be between 4 and 6 months when things looked at in detail. As with competition law generally, most developed nations now do have merger control regimes. So the two issues which have been looked at most closely in relation to life sciences mergers have been effects on price and effects on innovation. There's always a key question as to how you define the market. And generally, for mergers in this sector, the approach has been to take the anatomical classification system devised by the European Pharmaceutical Market Research Association. I wanted to just say a few words about Brexit. It's in the past now, but the consequences obviously are just beginning to come to the fore and be analysed as we move into the post-interim period. So first point to make is that the UK has always had its own standalone competition regime, the Competition Act, and this mirrors EU law, but it's not affected by Brexit. The law was there, and there's no proposal in the short term to change the basic provisions, Chapter 1, Chapter 2, which reflect Article 101 and 102 of the EU Treaty. There's quite a few issues still which will change. First is obviously, if you have a cartel that's being investigated, then the European Commission no longer has jurisdiction in the UK, so you're likely going to have two parallel investigations going on. And likewise for merger control, whereas previously the EU merger control was a one-stop shop regime, obviously that's not applicable now. So regardless of whether the EU merger control regulation applies, you need to analyse whether the UK merger control applies. Third change, not directly related to Brexit, but still relevant, is the National Security and Investment Act, should say 2021 there. This brings about a mandatory filing regime in relation to 17 different sectors. So again, when doing a merger in the UK in future, there may be a need for mandatory filing to be made. Damages claims is obviously a potential shift there, given that the EU Commission decisions won't be enforceable in the UK through damages claims, so there may be less follow-on litigation in the UK. Some of that may move to Netherlands and Germany. state aid, which is certainly relevant in relation to major investments being made. Finally, parallel trade, as we mentioned, it's always been a huge area of EU law, but our export ban so long an issue with a UK company saying you can't export to EU, or license agreement in the EU saying no export to the UK permitted. In principle, was the UK not part of the single market anymore? Why is that a problem? It's going to be an interesting area of law to determine in the future years. So we'll see how bold the authorities want to be. Thank you very much for participating today, and I've very much enjoyed speaking to you all this morning. Thanks.
The Mishcon Academy Digital Sessions. To access advice for businesses that is regularly updated, please visit mishcon.com.